Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3032. United States of America versus Theodore Douglas, appellant. Mr. Axum for the appellant, Mr. Hansford for the appellee.
Good morning, Mr. Axum. Good morning. May it please the court, counsel. Tony Axum representing the appellant, Theodore Douglas. I'd like to reserve 3 minutes for rebuttal. Police did not have reasonable suspicion to stop Mr. Douglas. Mr. Douglas's objectively innocent conduct was not of a nature that created reasonable suspicion. And it did not match conduct that the observing officer, Officer Jackson, based on his knowledge and experience, said typically met reasonable suspicion standard, giving rise to a belief that criminal activity was afoot. The facts in this case individually were entirely innocent, and collectively, even when combined with the high crime nature of the area, did not rise to the level of reasonable suspicion. Mr. Douglas was on a sidewalk open to the public in the middle of the afternoon on a sunny day, which itself was not unusual or suspicious. Officer Jackson testified that he saw someone walk up to him with a bag, and the bag didn't come from anywhere hidden. It was openly displayed. Officer Jackson could describe the bag, and the person handed the bag to Mr. Douglas, who openly accepted it. The bag itself was not a container that was associated with illicit transactions, but was a small, fancy leather backpack. And Mr. Douglas took the backpack and placed it on his back. And I realize that it's referred to as a backpack the entire time, but Government Exhibits 4 and Defense Exhibit 4 show that it's not actually a backpack with two straps on the side. It's a backpack with a cross strap. And I point this out because it might not fit easily on the back over the coat. It makes it understandable that Mr. Douglas took his coat off, put the strap on across. I mean, obviously, this is not captured on the body-worn camera. It's not described by Officer Jackson, but the government exhibits demonstrate that the strap is across, which might not be comfortable to go across the zipper of the coat if you want to unzip the coat. It's also understandable that in a high crime area that Mr. Douglas would wear something that he doesn't want others to see under his clothes, or something that appears valuable to, may appear valuable to others out of sight.
So let me ask you a question. Given your position about innocent conduct and basically entrapment, would you take the same position were we to accept your description of what the officer saw, but that given his experience, there was a ground to approach Mr. Douglas and his companion and ask some questions?
Your Honor, police always have the right to approach a person on the street just as any citizen can and ask questions. And
precisely,
that's what the police should do if they do not actually have reasonable suspicion but want more information. And that is, of course, is not what happened here.
Well, what I'm getting at is I'm not sure it technically and maybe you're more familiar with I than the law in this area, technically entrapment, but because the two men voluntarily went into this, I'm going to describe it as an alley, you say it's the sidewalk, and this officer saw conduct that was consistent with the type of conduct where he had previously indicated that there was exchange of illegal drugs or some other illegal activity. So I'm just wondering, where is it that you think the line was crossed? Is it when the arrest team came and pushed him against the wall and, you know, crossed his hands and put the handcuffs on?
No, Your Honor. I'd say in terms of the Fourth Amendment, there was not reasonable suspicion to actually stop him. So I guess
not even
no
to stop.
alias.
I thought you agreed the police could say to the two men, hey guys, I'd like to ask you some questions. Will you just stop a moment?
I don't think there's anything wrong with the police approaching someone and asking questions and asking them to stop and answer those questions.
Right.
But,
so that's my point. I just want to understand under that scenario, what is the action that was taken by anyone of the officers that crossed the line?
Well, I'd say first, the first officer to reach my client walked up to him and immediately touched him. And touching a defendant is a touchstone of seizure. I mean, it is, once he touched him, he was seized. So that took it past a consensual encounter of simply asking questions.
Let me ask you, in all due respect, that's a very broad reading of when an arrest occurs. If the officer just tapped me on the arm and said, could I ask you some questions? Here there was a push against the wall, I realize, but given that guns are everywhere, and this officer who called in the arrest team, and presumably the arrest team even knew the alley had a reputation for a place where illegal transactions occurred.
Well, can I address? I'd ask the court to look carefully at the exhibits submitted, both the pictures and the digital exhibits. It's not actually an alley. It is a sidewalk. It's a walkway. There is a fence on one side. There is grass on either side behind the fences, and then there are apartment buildings. So this
What
is
information did
But
the
I'm
officer?
trying to get at it that they were out of the general public view that you would be in, were you out on what I'm referring to a sidewalk?
I take issue with that, and that's why I can only refer to the record evidence. And the observing officer is parked in a car on the street. So that fact alone establishes that they were not out of public view. This isn't an alley. It's not a cul-de-sac. It is a walkway from one street to a parking lot on the other side. And it is open. The buildings, you can look down. It's
I don't
public
want to
and
argue on this point, Mr. Axel. I don't think this is key to your argument, but I just want to understand where the line is crossed in your view.
Well, I think the line is crossed.
The
Certainly,
initial touch by a member of the arrest team.
I think at the point that my client is touched, he's seized. But I think that the touch is escalated when the officer immediately puts handcuffs on him, and it only escalates from there. There are several frisks. There's accusatory questioning, and he's led away. There are officers on both sides. There's an overwhelming show of force by multiple
Did
officers.
the government contest that there was a seizure from essentially the moment that the officers encountered him below?
I don't think that the government.
Was a seizure
I don't think the
purposes
government
of
questions that it was a seizure from the outset of contact with.
What information did the officers who the two officers who were first on the scene, the uniformed officers who conducted the frisk, what information did they have?
The only information they had was what they had been told by.
Well, that's the question. What were they told by Officer Jackson?
According to Officer Poupart, he was not told anything except to stop this individual, person in the blue jacket.
He just gave them a description of who they were without any other information, or is that clear on the record? It's not clear to me, and I may be missing something.
I would. I'm not sure. I could take a moment and.
Let me tell you why I'm asking this. As I recall, there is a doctrine under the Fourth Amendment and also under Terry versus Ohio that the officer who conducts the frisk, conducts the search, if that officer receives information from another officer and the officer that conveys the information may be mistaken, that nevertheless the search is valid if the information that the searching officer gets would justify the search. You know that I haven't stated it very well. But
yes, I'm familiar with that line of cases, but that line of cases deals specifically with warrants and information contained in databases that is sometimes not accurate. Warrant license revocations.
Has it ever been applied in a Terry versus?
I'm not aware of it ever being applied in a Terry situation.
It's never been rejected, though, has it?
It hasn't been rejected, but there would be very good reason for rejecting it because it would essentially create a good faith exception to officers' observations in the field. So if they thought they saw something and the objective facts revealed that they did not see that, as long as they thought they saw it, their good faith reliance on what they believed at the time would sustain the Fourth Amendment violation. Fourth Amendment does not, the Fourth Amendment itself can't sustain good faith exception for officers' observations in the field. Terry and really every significant Fourth Amendment decision goes directly to what are the objective facts, not what did the officer believe or how did the facts appear. The question is not did it appear to be money. The question is whether it was money, and I'd suggest to the court that's the only way that the court after the fact when outside of the heat of the moment, actually a neutral evaluation of the situation can only look at the objective facts.
So one thing that troubles me about this case, and I'm going to ask your friend on the other side this, is Government's Exhibit 3 is the radio communication. And the officer, I believe his name, Jackson.
That's correct.
Who was undercover and did the observation. You know, he posted the lookout and the description of the people he wanted to be stopped, that he saw, you know, undertake this hand-to-hand exchange he thought might have been a drug transaction. And then he says he needed the officers to check that book bag for him, essentially giving them a directive that that's what he wants. He wants the book bag to be checked out. And the reason that alerted me is because, you know, as the Supreme Court has said in many cases, including New Jersey v. TLO, the whole purpose of the Fourth Amendment was because the framers were concerned and rejecting the, you know, pre-revolutionary practice of having soldiers without any sort of warrants or judicial supervision undertaking searches. in here, it wasn't the directive to stop these people, question them, see if, you can learn anything that would either confirm or dispel the suspicion that there was an illegal transaction. It was, I want you to stop them and check that book bag. So when do officers, without warrants, get the authority to just tell other officers to go essentially search a book bag, search a purse or other container that someone on the street is carrying?
I don't think there's any authority for that. There's certainly no authority under Terry to immediately search a container that someone is carrying. And I think the officers' actions in this case bear out that they were there to search the book bag. Officer Poupart, through a series of escalating intrusions into, and Officer Taylor, series of escalating intrusions into my client's personal space and personal property, walk up to him immediately, start squeezing his back. It's not what you would picture a typical frisk. They don't start at the top and move around. They both immediately go to the back, just as they were instructed to by Officer Jackson. That, we'd submit, was closer to a search at the very outset, but they don't stop at squeezing, manipulating, and trying to figure out everything in the bag. Officer Poupart and Jackson take additional steps. Officer Poupart at one point asks for consent to search the bag. They unzip Mr. Douglas's coat. They pull the coat down over his arm. These are not minor indignities. This is a full-on search. And the Fourth Amendment simply doesn't allow that process. I mean, to Judge Rogers' point, it would allow them to walk up and try to dispel any suspicion that they may have, while we're submitting that the facts in this case don't establish even the minimum of suspicion. Officers blow right past that point and are into a full-on search. To go back to where Officer Poupart is after he has unzipped my client's bag, my client's coat, and has been denied permission to search the bag, he then waits again for some other authorization from someplace else. You can tell on the radio. I think it's a fair assumption that it's Officer Jackson saying, yes, unzip the bag, and he unzips the bag. So he's being directed by Officer Jackson.
No, it shows that he's feeling around in the bag before he unzips it. And the video indicates that he found something.
That's correct.
Bag, right?
That's correct. But even within the context of Terry and a frisk, officers are allowed to frisk, but not to frisk, to search. And
well, the feeling of a hard object with a barrel and a handle on it is what the testimony was. It gave him probable cause to open the bag. That wasn't part of the frisk. Once he felt that, then there certainly was probable cause. You would not deny that, you?
If that is indeed what he felt.
What you have to argue is he was not entitled to even pat or feel the bag. That's got to be your argument, because once he does that and feels the outline of a gun in there, he's got probable cause.
Well, I think there are two aspects to frisking. I mean, one is the actual frisk, and two is feeling the outline of a gun. You're to frisk to rule out that there are not weapons. You're not supposed to frisk to search to figure out everything that is in the bag. And by Officer Poupart's own testimony, he testifies that he's trying to articulate what is in there. He is trying to palpitate what is in there, to figure out, those are his words, to figure out what is in there. That is a search. That is not, I am patting him down to rule out that he has a weapon. He does not actually testify that I felt a hard
to make sure there's no gun in there.
I'm sorry?
I mean, that happens in every frisk, where they feel in the pockets and in the belt and so on to make sure there's no weapon there.
That's
so
correct.
that's what he's doing.
That's correct. But again, this is not a pocket. This is not something against the body of the person. It is a bag.
Yeah, I understand.
And what he is describing is manipulating the objects in the bag to figure out what they are. That is a search. And I understand that it is a small distinction, but it is a significant one in the Fourth Amendment context. Because if every time an officer stops someone with a bag, they can methodically go through and feel each object.
Let's just be clear, though. You're not arguing, at least I don't believe I saw it in your argument, that you can't, that a bag is outside the scope of frisk.
I'm not arguing that a bag is outside the scope of a frisk. If, for example, Officer Hoopart had said, I felt something hard and wanted to figure out what it was, that's different. But he feels outside of the bag. He feels something that he says seemed to be a glasses case. And I continue to articulate what else was in there. At that point, he has not said, I figured out there was a gun in there. He doesn't put his hands on the bag and say, aha, there's a gun. That's not his testimony.
He doesn't have to say that as long as he has some cause to believe it may be a gun. That's
Right,
what probable cause means.
But his testimony has to be that I thought it was a gun. I mean, that if to get to probable cause, it can't be that I wanted to figure out everything that was in there.
Probable cause means it's sufficient if he says, I thought it might be a gun. That's enough.
Well,
Why don't you wrap up? We'll give you some time on rebuttal.
I mean, I suppose that takes me to really the third argument that I raised, which is if Officer Hoopart thought it was a gun, he did not react in a way that suggested that. It's our position that he did not, and it's inherently incredible that he believed that he was touching a gun and he continued to squeeze it for so long that he did not immediately seize it. If he thought he had probable cause to seize it, he didn't need to ask Mr. Douglas, may I have for permission to go into the bag. He didn't need to call radio in for further permission from Officer Jackson to go into the bag. I'd submit that looking at Government Exhibit 4,
we'd have to find that the district court findings otherwise were clearly wrong.
yes, this court would have to be left with a definite and firm conviction that the findings were clearly erroneous, that, and I'd submit they are so inconsistent with what we would expect from a police officer and human nature and knowledge that they are.
All right, we have your argument. We'll hear from you on rebuttal. Mr. Hansford.
Good morning, and may it please the court, Eric Hansford for the United States. Each of the defendant's three arguments for suppression fails in this case. First, the district court correctly concluded that when an experienced undercover officer who was operating in a block known for drug trafficking saw the defendant engage in a hand-to-hand transaction and then saw him immediately and hurriedly hide the backpack he'd just gotten underneath his jacket, the police had reasonable suspicion to stop the defendant for investigation. Second, this was a Terry stop and not an arrest. The police specifically told the defendant they were stopping him as part of an investigation for a minute, and the officer's on-the-ground decision to use handcuffs in this case was reasonable. Even if the handcuffing had been unreasonable, that would not be a ground for suppression. And third, the defendant fails to show clear error in the district court's credibility findings on the scope of the search, and instead the body-worn camera is very much consistent with the testimony about the scope of the search.
Let's start with your first argument, the first issue. Officer Jackson testified at, was it a preliminary hearing?
He testified both at a preliminary hearing, but the suppression hearing is what is really here.
Because the testimony that seemed to be cited in the district court's order was from the preliminary hearing, I thought.
I don't think that's correct. I think it's from a suppression.
But at any rate, the testimony that was cited, at least what I read, said that he did not know whether what was exchanged for the bag was money, some light-colored object that could be money but may not have been money. And then, of course, no money was found on the gentleman that he had the hand-to-hand exchange with, right?
So no money was found, but both the testimony of the officer and the district court's findings are that it appeared to be. So on A247, the officer says, the undercover officer says, it appeared to be the exchange of U.S. currency. And on A159, in the district court's opinion, it says that Williams the other person handed Douglas the backpack, quote, in exchange for what appeared to be money. So that's both in the district court opinion and the officer's testimony. And that is very much consistent more broadly with how
there was cash recovered from Douglas, wasn't there?
No cash was recovered from Williams, meaning the person.
But there was cash. Yeah, there was cash recovered from Douglas.
I do not recall if there was cash recovered from Douglas, but I think in terms of the lack of recovery of money, it was, and the district court addresses this in its opinion, Williams saw Douglas get searched, and then Williams continues.
So the reason I'm asking that question is it clear that whatever was exchanged was something Douglas gave Williams, or was it the other way around? I mean, or could they not tell what was going on?
So the undercover officer's testimony is that Williams, who's dismissed, gives the backpack to Douglas. Douglas then gives back a small light-colored object that the officer testifies appears to be money. But the lack of money recovered in this case, the district court says, Williams sees that.
I read the district court's findings different. I read that the district court found that there was a hand-to-hand transaction. The district court found that Jackson believed that it was currency. But I'm not sure what that gets you. He might have believed that it was currency, but he testifies under oath that he didn't really see, couldn't really see what it was, but he believed because there was an exchange that it was likely currency.
So
that's a hunch.
So it's two answers to that. First, it's not a hunch. He describes based on the size, the color, how it's being handled, why it is he believes it's currency, and that's in footnote 5 of our brief. That's collecting all those record sites. But the more important point, I think, is that the key is that there's an exchange, that it's not just someone receiving an object. So what this court says in Johnson is receiving an object has many innocent explanations, but this court in Johnson specifically says there was not an item exchanged in that testimony, in that very sentence, where the court is saying receiving an object has many innocent explanations. So this was a hand-to-hand transaction, just as the undercover officer testified he was looking for. And then on top of that, we have to look at the totality of the circumstances. So the Wesby rejects the sort of divide and conquer approach to looking at each factor individually and trying to determine whether or not we can provide an innocent explanation for each one. We have to look at the full picture. So what we have is that this is a block that's known for drug trafficking, a sidewalk where the undercover officer himself has seen prior drug deals. He sees the hand-to-hand transaction he's looking for, and then he sees Douglas make this suspicious movement of hiding the backpack underneath his jacket.
But I have not seen a case from our circuit where the object that is exchanged, even if we assume that it was some sort of reasonable belief that what he saw Douglas hand money to William, the object that he got in return in that exchange was a bag. It wasn't packaged like anything that, small baggies or anything like resembling drugs. He had no prior knowledge about either of these individuals. So the prior knowledge that he had was of the neighborhood and what occurred in the neighborhood. So it seems to me that we would be breaking new ground to say that this is reasonable, articulable suspicion to walk up to somebody in broad daylight who's in a public area after making an exchange where you can't even be sure that it's currency, but you see someone hand someone something and get handed something back. And it's a bag that they put on and then they put their coat on over it. And we're going to assume that that's concealment, even though furtive gestures is only credited when it's furtive because you're trying to hide something from someone you know to be police. But this was an undercover. And so they weren't trying to hide anything from the police. So we're going to break new ground and say that you can just walk up to somebody and then handcuff and detain them based on that.
So I think there was a lot in that question, and I want to kind of make 3 points. I don't think this would be breaking new ground. I think specifically the Green case that we cite in the briefs from this court finds probable cause in very similar circumstances.
There's a lot more in Green.
There is more in Green, but it's also probable. Well, I'm not sure there is a whole lot more in Green, but there is, we agree there's more in Green, but it's also a much higher standard of probable cause. This is a reasonable suspicion. The question is whether the police can stop the person just to investigate what's going on.
Well, they were told, I want you to check that bag.
So
that's what the directive was. You agree with that, right?
So I do not agree with that, but so Your Honor.
I didn't hear that on the tape. You want me to tell you where that is on the tape?
So I think there were a number of questions about reasonable suspicion. If I could address those before we go to the scope of the frisk, because this court also.
Well, was it a frisk? It goes to the question of, was this a frisk or was this stop them so you can check the bag?
So I'm happy to address the frisk, but I do have the court asked me a number of questions, including about furtive movements that I do want to be able to address. The questions about whether or not furtive movements or concealment can be considered absent the police involvement. The Green case specifically says, it's another undercover officer case, specifically says when the people are concealing the object that is being exchanged, that is something that provides the police with suspicion. That's one of the key Green factors that it cites. And that's an undercover officer case that is not in response to police presence.
So if somebody gets something and they put it in their pocket, that's concealment?
No, Your Honor. It's all.
Well, they're hiding it. So every time someone puts something somewhere where it can't be seen, that's suspicious concealment.
No, Your Honor. But so you have to look at the circumstances and whether or not it looks like they're hiding something or they're not. So in this case, what the officer describes is that he takes off the jacket hurriedly, he puts the backpack on, then puts the jacket over it. I think this court is supposed to use its common sense in trying to assess whether or not that's suspicious. The officer testifies that it is suspicious to him, the experienced undercover officer, and that is very similar to what this court found in Green was suspicious and helped provide the reasonable suspicion. I think it's also, I'll cite the Supreme Court's Citron case, which is the Terry companion cited in the reply brief. There, the court cites furtive tiptoeing in an apartment hallway. And that is, I think, actually the source of the furtive movements or furtive actions kind of case law. That is not in response to police presence. That's just.
You know, I was a public defender for 10 years, and there were a lot of people who I represented in their families and lived in neighborhoods like this and made way worse neighborhoods than this. And they did things that were a little different than the way you and I might do. They did things like, guys didn't carry wallets because the wallet was just a convenient compartment for a robber to steal all of their money. Instead, they hid their money. Women hid their money in their bra and things. If they wore a purse, it was a very small purse that they could put underneath a jacket so they couldn't be seen. That's another consequence of living in a high crime.
Sure, I
That's
do.
why I'm asking you these questions about concealment.
Of course, Your Honor. And I understand that there could be innocent explanations, especially when you're taking the factors one by one. But the question here, it's far less than preponderance of the evidence. It's less than probable cause. It's just whether or not the police can stop the person to investigate what's going on. And here we do have very good record evidence from the undercover officer that he's looking for this sort of hand-to-hand transaction. He describes the backpack transfer as being consistent with this bulk narcotics or firearms transactions. He's looking for people to hide as part of these hand-to-hand transactions, to hide what they're doing, consistent with what this court said in Green. And so we do have the record evidence.
Where was Williams carrying the backpack? Did he have it on his, was he carrying it by hand or was it on his back?
He was just carrying it by hand, was the record evidence in terms of that.
Yeah.
Your Honor, you also asked about the frisk here. The testimony or the undercover officer saying to check the bag, I don't think that's cited in the briefs or suggested that that's kind of the reason for the frisk. My recollection, so I haven't specifically reviewed that part of the
it's in Government's Exhibit 3.
That's true.
Radio communication.
Yes, Your Honor.
That you put in evidence, the government put in evidence.
So all I'm saying is that my recollection is that comes after the frisk. It may be wrong because I haven't specifically checked that because I don't think that was an argument that was made, but my recollection is
that Officer Jackson said that after the frisk had occurred?
That is my recollection in this case. But I think the more important question is that what we're operating on is objective standards, not subjective standards. And this frisk in this case was proper. As Judge Randolph was saying, they feel an L-shaped object in the backpack. Indeed, if you look, especially at Government Exhibit 4, but if you just look at appendix page 150, which is a still photo from the body-worn camera, you can see the L-shaped outline of the hard object at the very outset of the frisk.
Which exhibit is this?
This is, I believe it's 4, but it's A150 in the appendix. Appendix page 150 is where you see that. You can see it better in the video where he's moving the object and you can see this whole L-shaped move. But that is where you're seeing. And more importantly, I think the question is not whether the body-worn camera definitively proves what the officer is saying, but whether the officer does testify that he feels this hard object and recognizes it as a gun in the very first seconds of this frisk. We collect the kind of cites on page 7 of our brief. And so the officer is testifying that he knows almost from the outset that he has a gun in this case. And so at that point, the officer is free to squeeze the object to make sure that it is a gun. As long as he's looking for a weapon, he is free to do those things. And so that does not go beyond the scope of the frisk. I think this court.
So you would say that distinguishes this from Minnesota v. Dickerson, where the officer squeezed the bag and continued squeezing, not because the officer thought that there was a weapon, but because the officer just wanted to figure out what was in the bag.
That's correct. And this court in Johnson specifically says the limitation imposed by Dickerson is that once the officer finds an object on the person of a suspect, he may not palpitate it more than is necessary to determine whether it is a weapon. As long as he thinks he has a weapon, he is allowed to determine if it's a weapon and to take the weapon to disarm the person who he's stopping for officer safety. I mean, that's what happens in Terry. Holmes from this court stands for that proposition as well. The Dickerson issue is when you go beyond looking for a weapon, when you have an object you know is not a weapon, you are continuing to search. That's when there's an additional search. That's when there's a problem.
So I suppose one of the questions here, isn't it, that most of these cases occur where the outline or the hard object that seems to be a gun is on the physical person of the defendant, not in a separate bag that would have to be unzipped for the person carrying the bag to actually take it out and threaten the officers. So what do you do with that fact?
So I think there are two parts of that. One is that I understood from Mr. Axsom's argument earlier that he's not disputing that part of the permissible frisk was searching the backpack. In this case,
I wanted to ask my question, answer my question.
Sure. So what we have here is that the defendant, he's wearing the backpack and it's under his jacket. So if you watch the body worn camera, there's not like it's not like there's a separate bag that they are kind of feeling that could be easily separated from the defendant. He's wearing the backpack underneath his.
To protect the officer, all he needs to do is take the bag under your presentation. There's no reason to open the bag.
I mean, I think the invasiveness of taking the bag would be more than just frisking the defendant. Because the bag is under the jacket, in order to take the bag, they would have to unzip the jacket, take off the jacket, take off the backpack.
The physical difficulty of the defendant threatening the officer with the gun, unless he takes several steps. Either he has to, as you say, take off his jacket, then he has to take off the bag, then he has to unzip the bag. Most of the cases don't present this type of obstacle to getting to the source of what may endanger the investigating officer.
So I think that's kind of looking at it from hindsight.
No. The arresting officer knew that what he felt was under the jacket in a bag. So that's not after the fact. It's what he was presented with the facts. And you do not want to acknowledge what's in the government exhibit about the instruction from Jackson was to check the bag. That's very different than the Terry stop for purposes of investigation, where the officer can take reasonable steps to protect himself from injury or something like that.
So what the officer testifies here is in the first 5 seconds or in the first few seconds of frisking the defendant, he feels this gun. He feels this gun immediately. And so I'm not sure if the court is asking about that initial feeling of the gun or if the officer can take the gun out.
Going back to Terry and what the Supreme Court Terry was concerned about, and what most of our cases, and you haven't cited one that I'm aware of, are concerned about officers' safety in approaching a defendant. So here, Jackson didn't say, I think there's a gun in the bag. He said, search the bag.
So we do not think
Distinction between those facts and the usual facts where the defendant who is being investigated by the police in this Terry context, has ready access to a weapon?
So this court's cases do not require the police officer to figure out exactly how easy a weapon that's on his body is going to be.
But if I have, take the hypothetical, I have it in a locked bag. I can't get to it. The officer can't get to it until I unlock the bag. And essentially, it's locked here to the extent that the officer knows it's under the jacket. So it's unavailable to the defendant until he takes off the jacket. And then, because whether it's described as a backpack or a cross-strap bag, he has to take that off too. And I think, talk about objective facts and totality of circumstances, I don't think you can ignore that. You have to come to deal with it. And plus your own exhibit directing the officer to check the bag.
So, two things. One, Mr. Axum, I believe, just conceded that it's okay for the police to be frisking the back, that is permissible.
I wish you would deal with my questions, right? Because
Sure.
what I'm dealing with is what the Supreme Court was concerned about, namely officers' safety. And so protective searches, protective frisk, taking the totality.
So the case law, I'm sorry, Your Honor. So the case law says if a person has a weapon on them, or indeed ready access to a weapon,
I know what the cases said, and those cases are not talking about a defendant having to basically unlock the object in which there may be a gun.
So here the object was not locked and the officer.
There's an easy answer.
I know.
The answer is what is the office when the officer feels something through the coat and in the backpack? What's he supposed to do?
Right.
Say, "Oh, sorry, I bothered you." Unleash the handcuffs and let him walk away? I mean, it would be a dereliction of duty for him not to investigate further.
Question is whether he had a duty to undertake that in the first place. Let me ask you this question. What is the evidence as to whether they frisked his person and when they frisked his person?
So meaning the rest of his body.
Yeah, what you normally happen in a stop and frisk situation where you frisk the person, you pat them down.
So
did they ever pat him down, and if so, when?
I believe they do, and I think it's in I guess it's Defense Exhibit 4, which is the partner's video. I think she is searching the front of him, but I think the officer immediately feels the gun. Once he feels the gun, you can see he's tightened his grip on the defendant.
Because the first thing that he does is handcuff him, pull the jacket down, and start filling the backpack.
No.
Well, he doesn't pull the jacket down for a couple of minutes. He leaves the jacket. The jacket is up for the first couple of minutes. The first thing he does is he pulls him over and then he starts frisking his back. And within seconds of starting to frisk his back, he feels the gun. And again, you can see this in the body. And this is also what the district court's findings are. This is how the officer.
One of the photographs shows that.
That's right. That's A150. Appendix page 150 shows that gun. So what the officer's doing is he starts the frisk with the back. He immediately feels a weapon. At that point, the defendant, I think as Mr. Axum, the defendant is not going to be released until the officers recover that weapon in this case. But the officers are allowed to go in and to recover that weapon once they feel a gun in his backpack.
All right. Any other questions, Judge Rogers?
No, thank you.
Judge Randolph?
No.
We'd ask this court to affirm.
All right, thank you, Mr. Hansford. Mr. Axum, you didn't have any time. We'll give you 2 minutes.
I'd take that time to refer the court to what Officer Jackson said, and that he may have at some point said something appeared to be money, but that was explored further on cross-examination, and that is what is supposed to happen. You're supposed to figure out what exactly the officer is saying. What do the words appear to mean? And Officer Jackson conclusively explained that he did not know what he saw. He was too far away. He couldn't tell it was money. He couldn't even tell if it was paper. So that is at 299, A299, A278. And I think that's conclusive. With regard to concealment itself is a generic act. We conceal things. I conceal putting my pin in my mouth. That is a generic act. And because when you have something that is generic and ubiquitous everywhere, people conceal things all day, as is their right under the Fourth Amendment, as the court points out. In order to attach some criminal motive to it, the police have to explain why. And that did not occur here. The officer didn't say, I've seen people who are selling drugs get a backpack and put it under their coat. That's their MO. He didn't do that. So the government, if that was the telltale sign of a drug transaction, should have elicited that testimony from the officer. They didn't, because it's not, because concealment is a general act, and even the concealment in green that the government relies on very strongly is concealment of drugs. They are at sight. You can identify them. The concealment here is of a bag, something that is innocent of itself. So it makes sense that you would try to conceal something that everyone knows already is criminal. The other thing about green that I point out is that there was currency, paper U.S. currency in green. So it was an exchange of something, small objects, presumably drugs, or paper U.S. currency. So green is not on all fours with this case. That is simply inaccurate. The other thing that I want to say, the government keeps referring to a concession. When I concede, I will say I concede. I have not conceded. I admit that I did not raise a challenge to this search of the bag as part of as a separate search from the frisk. But I do not concede. I want that to be very clear. The last thing that I would refer to is Officer Coupart and his testimony. And I'd refer the court to A380, where Officer Coupart is asked, now, when Mr. Douglas says it's a glasses case, at that point in time, you also agree there is at least a glasses case in there. Yeah, or a similar object. What you are trying to figure out is if there is something else in there. The answer, right, if there is something else in there. By Officer Coupart's own admission, he did not know whether there was something else in there. He was trying to figure out whether there was something else in there. That is a search. At the moment he is trying to figure out and not patting down and immediately realizing that it is a gun, it is a search. And it is beyond the scope of Terry and required probable cause.
Thank you. We have your argument. We'll take the case under advice.
Case number 22-1792. Ian Scott-Anderman and David Supley, appellants, versus Robert Martinez et al. Mr. Keegan for the appellants, Mr. Hudson Platt for the appellees.
Morning, counsel.
Good morning, and to counsel as well. I'm Thomas Skagan, and I am counsel for the plaintiffs' appellants, and I'd like to reserve 3 minutes of my time. On two major grounds, the trusteeship of District Lodge 142 is illegal and even void ab initio, of no effect, to quote the leading law of the circuit. And under the law of the circuit, the elected leadership should be reinstated, should go back to the status quo before this void trusteeship was put into place.
Let me just clarify a couple of things. The trusteeship, though, did not depose the elected leadership. That happened prior to the trusteeship, right?
The formal trusteeship did not, but trusteeship has a functional definition under 402H. It is any method of control or supervision. It's important to keep in mind that when the LMRDA was passed in 1959, parent unions had all sorts of names for things that were trusteeships, but were not formally called trusteeships. The removal of the plaintiffs without any notice as to the specifics was on January 25th, and the trusteeship notice was on January 26th. They were twin, and the removal of the elected leadership of a district lodge of 20,000 members, their elected leadership, summarily, without any hearing, by one person, defendant Cervantes, not even by the entire IAM, just by her, is certainly a method of control or supervision and a trusteeship. And I will use those terms, I will use the broader term of trusteeship.
So why is there a Title I of the Act then? If Title, I don't understand.
Well, Title III is, as various courts have pointed out, including the Sixth Circuit, we cited Thompson. It's for the district lodge itself. It is a claim of the district lodge on behalf of the entire membership. The Title I is an individual claim of the officers to prevent the removal for speech. However, the Supreme Court in Lynn qualified that individual nature. In Lynn versus sheet metal workers, or sheet metal workers versus Lynn, the Supreme Court said, oh no, this is not just an individual claim. If the elected officers are being removed because of their speech, the members who elected them or who represented them are also chilled with respect to their speech. So even the Title I claim has a dimension that is collective in the Supreme Court's understanding of Lynn versus, in the Supreme Court statement is the rationale for Lynn versus sheet metal workers. And the Title I issue remains in this case. We have a separate Title I count, as this court is aware, and that removal for speech has a chilling effect. It is not that we are seeking to lift the trusteeship under Title I. We did say that in the original complaint, that that was one of the prayers for relief. But we concede that Title I is not a remedy for lifting the trusteeship. But it is clear from Lynn that officers do not lose their elected positions because of speech and just because a trusteeship is in place. They retain them and they retain all their rights. And in this case, there would never have been, Your Honor, there would never have been any trusteeship without the removal of the officers. This was payback. It was a revenge against Scott-Anderman and Supley for challenging her for election and for calling her out for financial fraud.
Let me turn to another issue. The statute specifically says that a trusteeship can be authorized or ratified after a fair hearing. You agree with that? Right?
That's correct, as interpreted by this court in the mine workers decision.
I'm asking you what the statute says. The statute says it can be authorized or ratified.
That's true.
So are you taking the position that if a trusteeship is imposed without a hearing and without a valid finding or presence of an emergency, But then within a short time afterwards, there is a fair hearing, and the grounds, just for the sake of this hypothetical, the grounds to justify trusteeship are proven at that subsequent hearing. Are you saying that that can never cure or be the basis of the imposition of a trusteeship if there had been an invalid trusteeship imposed previously?
Yes. And that's
why would that be, given what statute says?
Because, as this circuit pointed out in the mine workers decision, it begs the question as to whether there is a fair hearing, a post-ratification. If there was no emergency, and
I don't see any argument in your brief that this wasn't a fair hearing.
But yes, there is an argument that it is not a fair hearing. We say, first of all, the district lodge, once it is sidelined, no longer is able to present a case. There was no district lodge to protest this trusteeship. And second,
nobody showed up at the hearing.
Oh, no, people showed up, including the lead advocate in the case, Joe Tiberi.
But your clients didn't show up.
But they were removed on February, the trusteeship hearing was on February 16th. They were removed by Cervantes from, they were not just removed on January 25th. They were then banned on February 9th, a week before the post-trusteeship.
So they were prohibited from participating in the hearing?
They were prohibited from representing the district in any capacity. That was you have no ability as a member anymore to represent the members. You couldn't hold
Is that a full-time position?
It was a full-time position.
And both of your clients, they were full-time?
That's right. Secretary, Treasurer, and President.
You know, I wonder, you keep mentioning mine workers. The statute itself does not require a hearing for a trusteeship to be imposed. It only says that if the hearing is, if there is a hearing and it's a fair hearing and it may be before or after, then there's an 18-month immunity. But the statute doesn't require a hearing. And in mine workers, there was no hearing, correct?
Oh, that's correct.
So anything that mine workers said about what the situation should be if there had been a hearing after the trusteeship or before is totally dicta. And I don't see any case in our circuit that has ever adopted that proposition. But maybe a district court case, but I'm talking about in this circuit. Is there any?
Well, mine workers is that case because mine workers says, Your Honor, mine workers says that if there is no, it questions the good faith of the parent union if it doesn't provide for a hearing. And it gave specific guidance that not just mine workers, but this circuit, again, in mail handlers, affirmed in 1989 the same rule. It was very specific guidance going forward. And the example
was a case where there was an emergency imposition of the trusteeship. And then without a hearing, but there was a declaration of an emergency, as I recall. And then they noticed a hearing, and the local tried to enjoin that hearing because they said that hearing would interfere with elections or local union business, and that was denied. And then the hearing took place, and the trusteeship was imposed or ratified, and there was a proceeding by the national to enforce the trusteeship. And the court said, well, that's moot or not really right now because that's going on before the district court, and the district court should act and then will act. That presumes then that trusteeship could be enforced, right? Well, so if if it couldn't be ratified, so to speak, by hearing after the fact, then there would have been no reason in mail handlers to say anything about a possible action on a motion to enforce that trusteeship.
But the validity of that trusteeship hearing wasn't before the court of mail handlers. The mail handlers was concerned with a second independent trusteeship for a failure to hold an election. The first one was for financial fraud, and the court said that because the proceedings, actually, I think the magistrate judge became sick. Because the proceedings down below this is moved, we've moved past it. And we're just focused on the second not financial fraud, but trusteeship for not holding an election. And that trusteeship, the court did apply the mine workers rule and said that the district court couldn't enjoin the pre-trusteeship hearing, but after it was held, or the prior hearing, it could enjoin the imposition of the trusteeship. I would like to go back to Judge Randolph's question as to whether or not there could be a fair hearing. In this case, it's a perfect example of what happened. First of all, there are no prior hearings. There are no prior hearings under the IAM Constitution, ever. It's always shoot first and ask questions later. The district lodge has been sidelined. It has no institutional voice, which is the whole point of the statute, is to give the district lodge or the subordinate body a voice. They don't have a voice in a post-trusteeship hearing. So it's problematic to have this statute that says, oh, the district lodge can protest, can present its case to the parent union when the district lodge has already been incinerated, more or less legally.
Before you sit down, there's a question that's actually a preliminary question that I'd like to ask you a few questions about. It's the mootness argument.
Yes.
And your count, was it count 6? Is the Title I count?
It is the
count 6.
Yes.
And that count is clearly not moot because you're seeking back pay.
That's correct.
Which is why I asked you whether they were. So that count is not moot, but we have to remember we're here on an appeal from a denial of preliminary injunction. And I'd like you to address the question, what kind of an injunction can be issued now since there's been so much water over the dam and there are new officers who have been elected?
No, not yet.
Well, they take office in January, what?
There has been no election yet.
Oh, I thought it was supposed to be on the 29th of November.
To my knowledge, there has not been an election, but there's nothing in the record.
But,
well,
the allegation here maybe I misread this, but I thought from the defendants was that there was a new election scheduled for November 29th.
Well, let me address the question as to the new election. First of all, that election is void because the elected leadership has been barred from running it. But more important, if this trusteeship is void ab initio, then this parent union, IAM, has no legal authority to conduct the election. And yes, of course, to go back to the status quo ante, to reinstate the elected leadership. And by the way, there was an elected election going on in January and February of earlier this year that was stopped by the parent union, and now there's a new election.
So if I understand your point, that it is, and I'd like the defendants to address this. The point is, it's not moot because, forget about count 6, okay, for the moment. It's not moot because they were barred from ever running again. So even if there was another election, an injunction, a preliminary injunction would prevent the bar, and you'd have to have a new election. That's your point.
Well, or go back to the old election. There was an election going on.
Well,
that was stopped.
Yeah.
And if we went back to the status quo, that election would just play out the way it had before. So if it's void, it's void. They have no authority to conduct it. But more to the point, it's not just the Title I claim where there's a chilling effect on the members. If the members are having an election where the rule is you cannot put in place anybody who is going to challenge Cervantes for financial fraud, or you will be trusteed. They are not then able to have officers of their own choosing. There is a continuing irreparable effect, not just from the Title I claim, but from the Title III claim, because there's an enduring structural effect from the Title III claim.
All right, thank you.
Let's suppose I, for the sake of argument, that we were to find that the initial imposition of trusteeship was void ab initio because there was no declaration of an emergency or emergency basis for doing so without a hearing. But we found that eventually there was a hearing, and those grounds satisfy and justify the imposition of the trusteeship on March 17th. And so there was a void trusteeship from January 26th to March 17th, but then it was not void after that. What harm or what grounds would there be for what injuries resulted from that period of voidness and that would justify the imposition of preliminary injunction?
But Judge, it's not just a limited period where it's void and suddenly it becomes unvoid. It's void from the inception. So what the relief in this case would be to reinstate and go back to have a prior hearing again with the courts.
Let me ask it this way. Suppose a district court judge gets a motion for a preliminary injunction, complaint, motion for a preliminary injunction with a bunch of declarations attached and a proposed order, and without even hearing from the defendants, signs the order and says, enjoin. Defendants say, that's unfair. We want to file our pleadings. We want to have a hearing. And the judge gets all the pleadings, has a hearing, and then signs the same order and says, I found a basis for entering the injunction and I'm entering it, and signs it. And it comes up to us on appeal. And we find that what the judge initially did was in error, but what the judge did after the hearing was not. Are we supposed to vacate the second injunction?
Well, as I understand the question, what should have happened in that case is that the parent union can just restore the status quo ante. They can have another prior hearing. That's not barred, but they have to go back through the trusteeship procedure. And there's one other thing that I wanted to get in before I sat down.
You're not answering my hypothetical. My hypothetical is that if the district court enters an erroneous order, but then follows the correct procedure and later enters a proper order, we're supposed to vacate the second order because the first one was erroneous?
In joining the trusteeship?
For anything. It doesn't even have to be a trusteeship. It can be an injunction over anything. I'm just asking about what a court is supposed to do or how it works if a body takes a void action, a legal action subsequent that has the same result. Well, what do we do generally in that circle?
I think that that's taken up in the mail handler's case where the district court said, you cannot enjoin this prior hearing. You can't do that, but you have to let that go forward. That doesn't mean you lose the jurisdiction to bar the reimposition of the trusteeship. This situation is different because the lack of jurisdiction or the voidness results from not having this prior hearing, which is necessary except in an emergency to a fair hearing. I mean, the hypothetical that, well, what if it's a fair hearing later begs the question as to whether it can be what the district lodge removed when they didn't have to do it. They didn't have to do it. They could have had the prior hearing. And in this case in particular, it's very important to stress that the trusteeship panel had no authority to block the original trusteeship or say it was wrong. It could just talk about continuing it, and it had no authority to reinstate the elected leadership because of this slice and dice thing. Oh, well, we didn't remove them because of a trusteeship, when in fact they did. It does fit the functional definition of 402H. So the panel, this so-called post-trusteeship hearing, didn't ratify the removal of the officers. The post-trusteeship hearing said, hey, we don't have any authority to look at that, which was the whole point of the trusteeship. Why should the plaintiff show up at a hearing where they can't be reinstated and they've just been fined $265,000 each a week before and told never dare to try to represent the membership again? I mean, they were terrified, obviously, and there was no district lodge there to present a case, and that's why a post-trusteeship hearing was so problematic.
What has happened to the $270,000? Has that been paid?
No, we're still appealing it.
You're appealing that within the union?
Within the union, and it's been upheld at this point.
Okay.
And the ban has been increased from 5 years to forever. They can never hold an office, basically because of the phone bill.
All right. Any questions, Judge Rogers?
No.
Judge Randolph?
No.
All right. Thank you. We'll give you some time on rebuttal.
Thank you.
All right, Mr. Hudson Plush.
Good morning. May it please the court. Evan Hudson Plush, Cohen, Weiss, and Simon LLP for the appellee's defendants. This case involves an interlocutory appeal of the denial plaintiff's motion for a preliminary injunction, a mandatory preliminary injunction, seeking to lift the trusteeship imposed by an international union, the International Association of Machinists, or IAM, also known as the Grand Lodge, over one of its subordinate bodies, District Lodge 142. It's a case involving internal union affairs of a union trying to stop serious financial malpractice in a statute, the LMRDA, which presumes the trusteeship was validly imposed for a period of about 18 months. Before turning to the merits, however, I did want to address the jurisdiction of this court to hear this appeal in light of intervening events. And asking, or going directly to Judge Randolph's question, yes, elections have happened.
On the 29th?
On the 29th of November. Right. Not only have they happened, but the results, the ballots have been counted, the members have been notified, the election has been certified. The new officers are elected.
And they take office on January 3rd?
They will be seated on January 3rd.
Oh, perhaps you ought to offer an affidavit of some type for the record in this case, because all we have is your brief citing something on a website.
Thank you for that suggestion, Your Honor. The website is the website of the District Lodge, and those are the official results of the election. But if
I understand that, but that's not part of the record of this court.
Well, because it goes to subject matter jurisdiction, the court can consider it.
Why can't you just offer the affidavit? I mean, you're making representations here today that not only was the election scheduled for November 29th, but it has occurred and blah, blah, blah.
Yeah, it was, Your Honor, it was certified, I believe, 2 days ago or 1 day ago.
Why don't you confer with
putting an affidavit to that effect in the record for this court?
Absolutely not. We can do that.
Maybe you can just talk to counsel for the plaintiffs and get a stipulation.
Sure, I will gladly do that.
Take the issue out of the case, in other words.
And the fact that this election has occurred triggers another provision of the LMRDA Title IV. It was run, the election was run under Title IV, as we noted in our brief. Under Title IV, there's a provision 29 USC 483, which says the exclusive remedy for challenging an election already conducted is through the Secretary of Labor. The means to challenge that election is to go to the Department of Labor. First, you file internal challenges within the union, then you go to the DOL.
What is the site on that again?
29 USC 483.
Thank you.
and it's been interpreted by the Supreme Court in Local 82 versus Crowley, which is 467 U.S. 526. So reinstatement is just no longer relief that is available to the plaintiffs for numerous reasons. Number one is Title IV. Number two is that, as counsel acknowledged, they were not removed pursuant to the trusteeship, but pursuant to the shortage, which is a financial procedure under Article 7, Section 5. And while they
his argument is that it's really, tomato. You may say that, but it was really the trusteeship that removed. What's your response?
Well, they were removed the day before, and I believe his argument is that that removal in and of itself was a trusteeship under the definition of trusteeship under the LMRDA. And there is black letter law on that the disciplinary removal of officers is not a trusteeship. The lead case is Martinez versus Laborers, 410 F. 2nd 32 out of the Third Circuit. And so that was not a trusteeship. So they can no longer be instated.
What is it? What? Third Circuit.
Martinez versus Laborers, 410 F. 2nd 32.
Thank you.
Did that answer the question?
So what about the fact that the Constitution of the National Union seems to be in conflict, or is arguably in conflict with at least our mine workers case that interprets the statutory requirement of a hearing prior to the imposition of a trusteeship?
Two responses to that, Your Honor. First, I do believe that the mine workers case is distinguishable in this front because the Constitution in that case had no trusteeship provision whatsoever. There was no provision whatsoever, and there was no hearing ever held there. That being said, the way to read this Constitution in conformity with that decision, even with that distinction, is that when the president believes that there, in the language of the Constitution, that it is necessary to impose a trusteeship, it is necessary to impose a trusteeship to correct financial malpractice, that constitutes the need for immediate action, in the words of the mine workers case, that you need to go in there, you need to put that trusteeship in before the hearing because there is financial malpractice going on. You would not want those you're accusing of financial malpractice to have access to the bank accounts.
Was there evidence in the audit that documents, records were being destroyed?
The evidence of the record destruction is that after Plaintiff Scott-Anderman was removed pursuant to the shortage proceeding, she was to return her phone. And it was a district lodge issued telephone. And rather than returning the phone as is, she wiped it clean, such that they no longer had access to whatever.
So that's an additional reason, isn't it, for immediate action?
Yes, in our brief, we noted that was one reason. Another reason was that 4 days or 3 days prior to imposition of the trusteeship, the auditors had interviewed the former bookkeeper, who was no longer there. And that bookkeeper informed the auditors for the very first time that President Suppley had directed her to put fraudulent numbers, fake numbers, onto W-2 forms, federal tax forms, which was highly disconcerting. Right.
So what if we believe that our precedent requires us to only validate the imposition of a trusteeship without a hearing if there was a declaration of an emergency or if there was an emergency that justified it? And we find that the district court shouldn't have found such an emergency because the district court asked the defendants below if they were relying on such an emergency. They said no.
Your Honor, we did say no, and we said no. The reason was, to us, it was so clear under the laborers case that once the fair hearing is held, that whether there was an emergency or not is irrelevant. We have not waived, however, and there are cases on this, the ability to defend the district court's decision that there were, in fact, emergency circumstances. So though we believe your honors do not need to reach that question because the laborer's case is clear that issue.
I am not certain about this, but I just want to ask you, in the other circuits, is there such a law that says that unless there's an emergency, you have to have a hearing before a trusteeship?
In the Second, Third, Fourth, and Fifth Circuit, the law is very clear that you do not need to have an emergency at the time you impose the hearing, impose the trusteeship, so long as the Constitution so allows and a hearing is held reasonably promptly.
Right. Are there any circuits going the other way?
I believe the Ninth Circuit, though I'm not positive.
Okay, thanks.
And I just want to address the facts of laborers because they are a little confusing, but directly on point as understood. On June 20th the International Union imposed an emergency supervision without a hearing. The word supervision there is synonymous with trusteeship for purposes of Title III. Then on July 28th, the local refused to allow the trusteeship to be imposed. So the international went to court to enforce the trusteeship. And the district court refused to enforce it because it said there was no emergency. That case then goes up on to interlocutory appeal before the circuit. In the meantime, a hearing is held, and on August 2nd, the General Executive Board votes to continue the trusteeship. This court was then confronted with the question of whether it even needed to address the district court's July 28th decision refusing to enforce the trusteeship. And the court said, no, we don't need to do that. That's moot. That is no longer relevant. And the plaintiffs say, well, they're actually referring to a different trusteeship, and there was another trusteeship. And that other trusteeship was the reason for the mootness. But that's wrong. On page 1393 of that decision, the circuit very clearly indicates that the reason for the mootness was, quote, the supervision voted by the General Executive Board on August 2nd after a hearing before a special final. So it is quite clear, in our view, that renders irrelevant that decision. And the way to read that decision in conformity with mine workers is to say, to the extent it was, mine workers uses the term void ab initio, that it was void ab initio from the time it was imposed until there is a fair hearing. And that, again, is clear because in mine workers, there was no fair hearing, and the local had disaffiliated, precluding a fair hearing from ever happening in that case.
Well, they argue that there was no fair hearing here and couldn't have been a fair hearing.
Well, there was a full day of hearings. There was 28 voluminous exhibits entered. There were, before 3 uninvolved members, a trial committee of 3 uninvolved members, there was a stenographer. Everyone was invited. The plaintiffs were sent letters telling them they could attend and that they would have the right to enter evidence, to cross-examine witnesses, to challenge the trusteeship, and they did not appear. There are members who...
Your friend on the other side says, well, they weren't allowed to speak on behalf of the union, so how could they appear?
That is wrong. They were permitted to appear and speak on behalf of District Lodge 142 for why the trusteeship was not imposed. They were no longer officers at that time. They were at that time temporarily, it was not permanent yet, temporarily suspended, subject to an evidentiary hearing under the shortage proceeding, subject to an appeal under the shortage proceeding. But they absolutely could attend and challenge the trusteeship in that hearing. And just to briefly touch on the procedure under Article 6, the international president found that there was significant financial malpractice why he imposed the trusteeship, which was then found to be valid by the trial committee. And I just wanted to quickly go over what some of that financial misconduct was. The plaintiff, the Secretary of Treasury, Scott-Anderman, self-authorized payments directly into her own bank account without any documentation or approval. I've already mentioned the fraudulent W-2s. And And third, there was $270,000 what plaintiff supply in contemporaneous emails that are in the record acknowledged is Grand Lodge money, is international money. He moved out of the general account into a separate account, not properly disclosed, that was labeled a building corporation account. On top of that, the auditors found that the district lodge had been spending $200,000 additional over the course of 5 years on phones and electronics, 196 devices for 18 members. There's 18 staff members, as well as $50,000 for overpayments in vacation pay and bonuses.
Were the payments for the phones or electronic devices, were they made to, for example, Apple or a carrier, Verizon or something? Or
Sprint. They were made to Sprint, yes.
Okay. Before you run out of time, the plaintiffs say, as I understand it, that the case is not moot because as part of the trusteeship that was imposed, they were barred from running for office. And so the fact that there's been new officers elected wouldn't matter because they were entitled to an injunction reinstating them. Can you respond to that?
Yeah. I have seen no case standing for that proposition, but I think the boilerplate law is once an election has occurred under Title IV of the LMRDA, the sole and exclusive means to challenge that election
Through the
file a
Secretary
challenge
of
and then
Labor.
go to the DOL. So they could have, maybe should have challenged that election internally. I don't know if they will or did. Internally, and then go to the DOL, and the Secretary of Labor can then decide whether to overturn the election. But it is no longer within the province of this court to do so.
And the only relief that they could get on a preliminary injunction would be to, for an injunction, would be to reinstate them as officers. And you say that would be, in effect, challenging the results of the election?
Correct.
Okay.
And the other basis they sought in their request for relief was to hold an election. But again, that election has happened. So that,
But they couldn't run.
sorry?
But they couldn't run in the election.
Correct.
Okay.
All right, Judge Rogers, any other questions?
No, thank you.
All right, thank you,
Thank you very
counsel. Mr. Gagan, we'll give you 3 minutes on your.
Mill handlers did not affirm a post-trusteeship ratification for failure to hold a prior hearing. What happened in that case was there was no trusteeship, an emergency supervision. And by the way, I focus on the word emergency. The claim of the laborers was, this is an emergency. The district court said, no, it isn't. So it didn't go into effect. Then they had, so there was no trusteeship to ratify. Then they had a hearing for an emergency supervision later that laid it out in more detail. And there was a hearing, and the court said, look, this is moot at this point. And they focused on the second trusteeship. There was never a post-trusteeship hearing to ratify. And in this case, as I stated earlier, in this case, there can't be a fair hearing if, in absence of an emergency, no reason to not to hold a prior hearing, the parent union gets rid of the district lodge that is supposed to make the protest, bans the plaintiffs, and fines them $265,000.
Can you tell me what you're seeking? A reversal of the denial of a preliminary injunction.
And an entry of a preliminary.
Now, what kind of injunction are you seeking? What would the terms of the injunction be at this stage after the trusteeship is going to expire and there's been a new election, there are new officers? What sort of injunction are you talking about?
The status quo ante. Reinstate the plaintiffs as elected officers, allow the election that was going forward. And this wasn't a long time ago.
But you have to address the defendant's argument that to do that, the district court in its order would have to set aside the election that's occurred, and you can't do that without going through the Secretary of Labor.
That's not true, because under this court's decisions in both mail handlers and Brennan versus mine workers, this court has broad equitable power to correct a violation of a trusteeship of Title III. The Secretary of Labor under Title IV doesn't even take cognizance of that. So that has to be read, that 483 provision that counsel quoted has to be read with the broad equitable authority that this court recognized in Brennan versus mine workers and in mill handlers to undo the effects of a trusteeship. Congress was very concerned about these intrusions. And there is, if the election hadn't been held, it would, first of all, the election was held on an expedited basis to moot this. It was speeded up after this appeal was filed. And the attempt here is to argue to the court that we're out, you can't touch us anymore. But there is a continuing irreparable, remember, the members have not been allowed to have officers of their own choosing in this election because of the trusteeship, because of the irreparable injury. The Secretary can't address that.
To set aside the election, wouldn't you be able to get all of these remedies that you're asking the court now to order?
Okay, that's fine.
The order is very simple, and that is A, the trusteeship that was imposed on January 26th and 25th.
Answer my question.
I'm not sure that I heard it properly. I think there was a little static, and I apologize.
If the Secretary of Labor sets aside the election, then are not these remedies you're speaking of available to you?
No.
Why not?
Because for one thing, if the Secretary does set aside the election, it has to have it do so under a Title IV provision. We have a Title III challenge to the authority of the IM to conduct the election at all. And there is a irreparable.
I understand that. And the Secretary can take all that to account if you raise these issues. And suppose the Secretary decides to set aside the election.
The Secretary might, in its discretion, do that, or might not, in its discretion. The plaintiffs have a statutory right.
Counsel, deal with my hypothetical, please. If the Secretary sets aside the election, then are not the remedies you're talking about now available?
No.
Why not?
Because, as this court pointed out in mine workers, there is, even for a Title III violation, there is a remedy in damages. There is for the district lodge for its losses as a result of the unlawful trusteeship. There is a chilling effect and there is a need in particular, Your Honor, for a ban on the reimposition of a trusteeship. No, it is not moot, and you cannot get that relief under Title IV, and that's essential to the case.
I don't know of anything you haven't cited that would bar the Secretary in setting aside the election. And then you can pursue these other matters if you say the Secretary has no jurisdiction over the Title III argument.
First of all, the Secretary cannot set aside the election. Only a district court can set aside the election if the Secretary brings a lawsuit. And second, we cannot get the relief that we're seeking here, which is barring the reimposition of the trusteeship, ending this reign of terror at the top of the IAM. Every person who has, they talk about this.
I get your argument.
Okay. In fact, this might be the best way to conclude it. Every person who has called out defendant Cervantes for financial embezzlement, which she has not denied, on a massive scale, has been systematically removed. Pantoja, admittedly, appointed officers. Joe Tiberi, gone. Ian Scott-Anderman, gone, fined $265,000 for daring to raise the embezzlement charge. Supply, the same. That's what's going on. Systematic suppression of dissent. That's what Title III entitles us to have this court enforce the LMRDA and let members have officers of their own choosing, even if they call out their leadership for massive union corruption.
Thank you, counsel. We have your argument, and we will take the matter under advisement.